Hello everyone, and thank you very much for joining us at this Garden Court Community Care Team seminar. We're delighted that so many of you could join us this evening for a seminar on community care, the year in overview. My name is Tessa Buchanan, I'm a barrister at Garden Court, and I'm joined today by 5 fantastic speakers. Just to run through a little bit of housekeeping for you all at the beginning. Firstly, the webinar is being recorded, which means that the audio and the video of the panelists and anybody who speaks, if they're unmuted, will be recorded. And the webinar might be shared on our marketing channels, including our website and social media. You've all been placed on mute. If you have questions, which we welcome, then please put them in the Q&A window, which you should see at the bottom of your screen. There is also a chat function that's enabled for any other comments that you might have or other queries or feedback. But if you have questions for the speakers, please do put them in the Q&A box rather than the chat function, as otherwise they might be missed. There are instructions in the chat window. Or there will soon be instructions in the chat window if you have technical difficulties. And just to reassure you that the resources that you'll be seeing tonight will be circulated to registered delegates after the webinar. As I said, I'm joined by 5 brilliant speakers tonight. Firstly, Tim Baldwin, who will be talking to you about adult social care, Maria Moodie, who will be covering children's social care, Connor Johnston, who will be talking about asylum support, Miranda Butler, who will be speaking on trafficking, and Ollie Persey, who will be speaking on education. The plan is for the speakers to speak for about 1 hour, not each, but between them, and then there'll be hopefully 30 minutes for questions, although, as you know, never trust a barrister who's giving you a time estimate. We will be trying to stick to that so there's time for your questions. The community care team is multidisciplinary. We cover a wide range of areas, which means that we aim to cover any sort of community care issue that you might have, and we'll be showcasing that broad expertise tonight. But it does also mean that there might be areas discussed which are less immediate in your practice or less familiar to you, but we hope that we will have something for everyone tonight. So our first speaker is Tim Baldwin. Tim is a leading junior ranked in Legal 500 for many areas, including community care, court protection, social housing, and civil liberties. He has a broad practice and has appeared in numerous reported cases from the front line in the Mental Health Tribunal up to the Court of Appeal, and he will be speaking to you tonight on adult social care. So I will hand over to Tim. Thank you.
Thank you, Tessa. I just wanted to make sure that the screen that you're seeing is the appropriate one in terms of the slide. You're just seeing the slide, is that correct?
That's right. Thanks, Tim. Yes.
Thank you very much. It's always something I struggle with. Tonight, what I'm going to do is just highlight 5 cases that I've selected in respect of the past year in respect of adult social care. I'm going to deal with those in turn, but just to make sure that everyone understands where we are with the Care Act and COVID. As a result of the Coronavirus Act, there were easements in respect of the duties under the Care Act that were applied. Those were removed as of the 16th of July 2021. So all practitioners should be aware that if a local authority is still applying those, that's unlawful. And if there has not been reviews of people's care plan as a result of the imposition of those easements, that would also be arguably unlawful. So that's something, a general thing that people should be aware of as a major change in 2021. The first case I'm going to talk about is the case of BG versus Suffolk. And this is a case concerning meeting needs, and it concerned 2 disabled brothers who applied for a judicial review challenge to the defendant's decision that was made under the Care Act and under the eligibility criteria regulation to withdraw funding for their holidays and to cease direct payments to assist them in attending outings and recreational activities. So the Section 18 of the Care Act, and part of the defendant's duty is to meet disabled adults' needs for care and support. And under the Care Act, support has a broad meaning, and it could also include the power to pay for costs of holidays and recreational activities. And the court, in allowing the judicial review challenge, identified that. And it is clear that if an eligibility assessment under the Act identified a need arising from disabilities, a need for care and support, then that was a need which had to be met under the Act. So in this case, the need for holidays and direct payments for recreational activities was held to be a need that must be met. Also, one element of this, that if the eligibility criteria had not been met to fund recreational activities, in making its decision, the defendant in any event should have considered its power under Section 19 of the Act before deciding to cease all direct payments anyway. So this case deals with both the duties to meet needs and the discretion or the power to meet needs in any event. The second case I'm going to talk about is a rather interesting, if slightly peculiar case in terms of social care. This is a case of the Secretary of State for Justice versus the local authority, with C being an interested party, that being the subject of the decision. C was a 27-year-old male with a genetic disorder which caused him to have developmental delay and difficulty with social communication. He was subject to a deprivation of liberty standard authorization, but in 2018 expressed a desire to have sex and asked if he could make contact with a sex worker. And it was deemed that he had capacity to consent to sexual relations and contact a sex worker. So he had the requisite mental capacity to do that, but he could not do that could not make the arrangements himself. So the judge at first instance in a court of protection made a declaration that sex workers, care workers, would not commit an offence contrary to the Sexual Offences Act, Section 39. And the Secretary of State appealed that decision from the Court of Protection. And the Court of Appeal allowed that appeal and said that care workers were at a risk of committing an offence contrary to Section 39. And the Court of Appeal also raised several other issues. Firstly, concern about civil courts and declarations as to the meaning of statutes, particularly when there are criminal statutes. And it was doubted that the Court of Protection judge should have expressed a view or any view on this issue, even though the Court of Protection judge was charged with looking at C's best interests. The Court of Appeal also identified that causes should, under Section 39, should have the ordinary meaning in criminal law, and the judge's restrictive meaning and reading words into the Act was wrong. And there was an argument raised by the local authority that given Article 8 and Article 14, that in this context, Section 39 had to be interpreted differently. The Court of Appeal held that the European Court of Human Rights had not recognised access to sex workers and arranging access to sex workers as an issue that it ever grappled with, and that Parliament in legislating had created the correct balance. So this is one of many cases that have involved sexual relations and people with lacking capacity over the past year, but this is an unusual one in the sense of how it fitted into what was presented as appropriate care for this adult. The next case is a slightly older case, and this comes from December 2020. I thought it was useful to have this because this is a case that looks at charging decisions. In this case, the claimant applied for judicial review of Norfolk's decision to change the basis on which it calculated charges in respect of care in the community. The claimant was a 24-year-old woman with Down syndrome, associated physical disabilities, and severe learning disabilities. She'd never been able to work and was unlikely to do so in the near future. She was totally reliant on welfare benefits. Norfolk provided support under the Care Act to her and charged her in accordance with the means test under Section 14 of the Care Act, where they could not levy charges causing income to go below a certain amount and with certain disregards in respect of the ability to earn money from employment and self-employment. Norfolk introduced a new charging policy which reduced the minimum income guarantee under their scheme and brought into considerations employment support allowance and PIP daily living components in respect of their assessment of means. So the claimant's charge went up from about £16 a week to £53 a week. The court, in a judicial review claim, allowed the claim and held that the change in the charging decision and the policy discriminated against severely disabled people, contrary to Article 14 and Protocol 1, Article 1. And the court identified that severely disabled people were disadvantaged as compared to disabled people who could earn money from work, where they would get the benefit of the disregard for employment and self-employment. So this, on this case, identified that severely disabled people were a separate group for the purposes of Article 14, and that any discrimination could not be justified. The next case is Lancashire case, and it was in respect of ordinary residence issues. Here, the subject person had suffered a serious brain injury as a result of a road traffic accident in 1990 when 5 years old. They'd been living in accommodation in Lancashire, where they had bought it with their own funds, and it was under the control of a deputy out of a damages award. No community care assessment had been made, but in May 2010, they moved to a transitional rehabilitation unit in the St Helens area. And a dispute arose as to which local authority was responsible for funding JM's care at the unit. And unusually, this related to not anything under the Care Act, but a responsibility under the National Assistance Act 1948, Section 24, and also the National Health and Community Care Act 1990. So in this case, that the court had to grapple with those previous provisions. And the court held that the Secretary of State had not erred in deciding JM was ordinarily resident under the National Assistance Act 1948 for the purposes of payment of his care. And that was an application of the well-known case of Greenwich versus the London Borough, Greenwich versus Secretary of State for Health case. The final case I'm going to talk to, and I have 1 minute 13 seconds to deal with this, is to do with another complicating aspect of ordinary residence. And that was in respect of ordinary residence for the purposes of Section 117(3) of the Mental Health Act. The person suffered from a schizoaffective disorder, and they had been ordinarily resident in Worcestershire, and they'd been detained under Section 3 of the Mental Health Act 1983. In April of 2014, it was decided that it was in JG's best interest for her to move residential placement closer to her daughter in Swindon. She was going to be discharged from the hospital in Worcestershire. In July 2014, JG's period of detention ended. She went to a care home in Swindon under Section 117. At that time, she was funded by Worcestershire. In February 2015, she moved to Swindon, which was better able to deal with her needs. Again, this was funded by Worcestershire. In June, she was detained again in hospital in Swindon, and she was discharged for aftercare services. The dispute arose then, who was responsible for funding this aftercare? Originally, in accordance with the guidance, the Secretary of State held that she was ordinarily resident in Swindon. That's where she'd been living immediately before her second detention. Swindon sought a review of that decision, and the Secretary of State changed their mind and said they were an ordinary resident in Worcestershire for what they call fiscal and administrative purposes in application of the case of the Cornwall Council versus Secretary of State for Health in the Supreme Court. The judge concluded that the Worcestershire's duty ended by operation of law, so that the Secretary of State's decision was wrong. The Secretary of State appealed, and a Court of Appeal allowed the Secretary of State's appeal, such that the lady remained ordinarily resident in Worcestershire, and that was the local authority with a duty to provide care services and aftercare for JG. So that's my quick trot through. I believe I'm a little bit over time, but Tessa's not punishing me for that.
Great, thank you so much, Tim, for that really helpful presentation and for your pretty good timekeeping. I'll be scoring you all at the end, but that was pretty much to time. So thank you for that. To anyone who's joined us a little late, welcome to this Garden Court Community Care Seminar. If I could just refer you to the chat, which has some meeting instructions in it, including what to do if you have technical difficulties, and also the fact that the webinar is being recorded. Just to let you all know, and to remind those of you who were here at the beginning, we do welcome your questions. Please pop them into the Q&A box at the bottom, and we'll do our best to answer them once the speakers' presentations are finished. Our second speaker tonight is Maria Moodie, who is a specialist public lawyer with expertise in community care, as well as human trafficking, asylum and immigration, and housing. Maria was recently appointed as the international expert to the Council of Europe on sexual and gender-based violence, and she recently led a UK-wide trafficking research project for the British Institute of International and Comparative Law, looking at anti-trafficking law and policy. And she is going to speak to us tonight on children's social care. Thank you, Maria.
Thanks, Tessa. And Amy is going to very kindly assist me with my slides. Thanks. Thank you, Amy. Good evening, everyone. So I am going to cover children's social care cases in 2021. I'm going to start with a case of AR and Waltham Forest. This case involved a systemic challenge regarding local authorities' duties under Section 21 2B of the Children Act to provide secure accommodation to children in police custody who had been denied bail. This case really highlighted the widespread failure by local authorities to provide secure accommodation when requested to do so by the police under Section 38 of PACE. The evidence that was filed exposed that it was certainly the norm rather than the exception that children were having to stay overnight in police cells because local authorities, particularly across London, weren't able to provide the requisite secure accommodation. Indeed, Waltham Forest was unable to provide any example of a PACE request ever having been met. And in the case of AR, refused secure accommodation on the basis that the notice they'd been given by the police was too short And in any event, all of their secure accommodation was outside of London. The evidence also showed that in 2018, only one request out of 342 was met for secure accommodation across the whole of London. The Divisional Court in the first instance dismissed the claim on the basis that it involved a complaint about the nationwide lack of secure accommodation and placed the blame on the absence of central government funding. AR successfully appealed to the Court of Appeal, who found that the statutory duty under Section 21(2)(b) was imposed, in fact, on each individual local authority and not on central government. And there was no evidence to support the finding that it was the fault of central government. Although the duty to provide secure accommodation when requested is not absolute, it's a discretion that must be exercised in accordance with public law principles. And local authorities are expected to have in place a reasonable arrangement to provide the secure accommodation. The Court of Appeal highlighted that they could do so in a number of ways. They needn't necessarily provide the secure accommodation themselves. They could enter into arrangements with charities. They could make an arrangement for pooling secure accommodation with local authorities. But ultimately, it was held that Waltham Forest didn't have a reasonable system in place and was in breach of its duty under Section 21(2)(b). I believe that since this case, there has been steps taken to try and address the more widespread issue of securing secure accommodation. Next slide, please, Amy. Thank you. The next case is H and Swindon. This involved an unaccompanied asylum-seeking child who was placed in local authority foster care. H exhibited challenging behaviour that ultimately led to the breakdown of a number of placements and resulted in criminal charges and a period in prison. The local authority held a strategy meeting in which it was concluded that the risk of serious harm threshold for a Section 47 assessment had been met, but the assessment was never carried out for a number of reasons, including an age dispute and the local authority considering that they had insufficient evidence of trafficking, despite there having been an NRM referral and a subsequent positive RG and CG decision by the single competent authority. The High Court found that there had been a breach of the Section 47 duty in that the local authority had failed to initiate an inquiry which amounted to a departure from guidance without good reason, and that the local authority had been mistaken to assume that no purpose would be served by contacting the police or this single competent authority to make further inquiries about the risks posed to H. But the court found that there was no breach of Article 4, that the local authority had complied with its operational and procedural duties. There was an appeal to the Court of Appeal on the Article 4 ground. It was accepted that Article 4 was engaged in this case and that it wasn't necessary to show that loss had flowed from a breach of Article 4, but based on the facts of this case, although the local authority had failed to make the necessary inquiries, H had in fact been accommodated, supported and protected, and therefore there was no breach of Article 4. This case the judgment certainly lacks detail in relation to Article 4, and the findings are very fact specific. But overall, it's useful on the finding of the Section 47 breach. Next slide, please, Amy. The next slide is the section against the Secretary of State for the Home Department, which was a challenge to the no recourse to public funds scheme on a number of grounds. The one that ultimately succeeded and that's of interest relates to the Secretary of State's compliance with the Section 55 duty regarding children's welfare. The case involved a British child and a South African mother who'd been granted 30 months leave to remain subject to a no recourse to public funds condition. In relation to the Section 55 ground, the court found that the general statement in the immigration rules that the rules complied with Section 55 did not decide the question whether as a matter of law any particular provision was compliant. The question depended on the construction of the relevant provisions within the rules and within any guidance, which may mitigate or exacerbate the apparent effect of the rules. And so the real question was therefore whether, in framing Appendix FM in the guidance, had the Secretary of State complied with her Section 55 duty by ensuring that when caseworkers decided whether to impose a no recourse to public funds condition, they complied with Section 55. The court identified the following failings, namely that the rule in question didn't refer to the best interests of the relevant child and didn't reflect the proper approach to assessing best interests. Instead, it imposed a more stringent and narrow test than the one established in ZH Tanzania and FZ Congo. And the extensive guidance did not mitigate that deficiency. There were many references within the guidance to the Section 55 duty, but they were all in the context of decisions as to whether or not to grant leave, rather than whether or not to impose a no recourse to public funds condition. And therefore, the court declared that the no recourse to public funds scheme did not comply with the Section 55 duty. Next slide, please, Amy. Thank you. The next case is W and Z, and it's a case in which the local authority sought guidance from the court on the proper approach to applying for settled status under the EU SS scheme on behalf of children in its care, principally children under a care order or replacement order. It's estimated that there are approximately 3,300 children, looked after children and care leavers, who were eligible to apply for the EUSS scheme. The court confirmed that local authorities do not need the court's authorisation to apply on behalf of the child for the EUSS scheme, or to apply for a passport or national identity document in order to apply for the scheme. The justification being that the successful application under the EUSS scheme merely confirms the status quo with respect to a child's immigration status, and it doesn't alter the child's legal status, nationality, citizenship, or prevent them from returning to their country of origin at a later stage. Although the deadline for applications for the EUSS scheme has now passed, this case remains useful insofar as it highlights the negative impact of insecure immigration status on children and young people. And it also gives guidance on the responsibility of local authorities to address immigration issues for looked after children, which included that local authorities were required to identify those eligible to apply for EUSS and make the applications in a timely manner. That the duty extended to Section 20 looked after children, care leavers, children supported under Section 17, and children who were lost or abandoned, and not limited, therefore, to those who were under a care order or replacement order. And that immigration status of looked after children generally should be addressed as part of a care plan. Next slide, please, Amy. Thank you. This case, BF Eritrea, is a Supreme Court appeal concerning the Home Office's policy guidance for immigration officers as to when they could assess an asylum seeker as an adult, even though they presented themselves and claimed asylum as a child. The target of the challenge was criterion C within the policy guidance, which read, an individual could be assessed as an adult if their physical appearance or demeanour strongly suggested that they were significantly over 18, or there were other credible evidence, and there was no other credible evidence to the contrary. So this was a systemic challenge to criterion C, in that it created a risk that more than a minimal number of children would be unlawfully detained, having been assessed as an adult. The upper tribunal dismissed the claim. The Court of Appeal reversed that decision, finding that criterion C was unlawful for failure to recognise just how unreliable the exercise of age assessment was when conducted on the basis of appearance and demeanour, and that the guidance failed to take into account the large margin of error. The court suggested that the guidance ought to make reference to an individual being assessed as an adult only if an immigration officer believed them to be at least 23 or possibly 25. On a without prejudice basis, the Secretary of State changed the policy accordingly, but then appealed to the Supreme Court, who allowed the appeal, finding that the policy wasn't unlawful. There was no obligation to promulgate policy in relation to the application of statutory rules, and the Secretary of State would have been just as entitled to have no policy at all. There was no requirement for the guidance to remove the risk of possible misapplication of the law on the part of those who were subject to the legal duty, and that criterion C included an allowance to give the benefit of doubt to an individual who claimed to be a child. The policy has now been has reverted to its original wording in that any reference to being over 25 has been removed, although there is now a need for 2 immigration officers of a certain level of seniority to make the assessment. Next slide, please. I'm aware that my time is almost up. There are, just for the sake of completeness, I've included a reference to further age assessment cases. They don't add anything much to the existing case law. They restate the principles. There's some further cases. Sorry, next slide, please, Amy. This case concerns a Section 117 mental health assessment that was found to have been unlawful. And Tim Baldwin's actually done a very useful summary of this case on the Garden Court Social Welfare website. And the final case is very fact specific, but I've included it because it contains a useful summary of the relevant authorities and the correct approach for determining whether a child is looked after under Section 20 of the Children Act. Thank you very much. I hope I've scored well on my timekeeping, Tessa. No, you were very good. Thank you. And thanks very much for that brilliant presentation. We will next be hearing from Connor Johnston. Connor specialises in housing, homelessness, asylum support, and of course community care. He is a co-author of Housing Allocation and Homelessness, the 6th edition of which is in the process of being published. It is hot on the press at the moment and will come out very soon. He is also a member of the EHRC's panel of preferred counsel and is in the process of co-editing the Migrant Support Handbook. And he will be speaking today on asylum support. Thank you, Connor.
Thanks, Tessa. So yeah, that's right. I'll be covering asylum support. And just to be clear, what I mean by that is both support under Section 95 for asylum seekers and support under Section 42 for failed asylum seekers. There's been an awful lot that's happened in this field in the last year, really the majority of which is related to the pandemic. So the fact that we've been in the midst of this pandemic has led the Home Office to put a temporary pause on evictions, which created a backlog of people who needed accommodation. And as a result of that, there was an increased use of hotels to place people in, sometimes for really quite significant lengths of time, and also the use of the barracks in Napier and Penally to house asylum seekers. So as I say, there's been a lot that's happened. So I'm going to focus on just a few of the key cases and try and draw out a couple of legal principles from each of them. To give a bit of coherence to what I've been saying, I've tried to group my cases thematically under the headings of, firstly, who can get support, secondly, how do you get it, and thirdly, what do you get, to try and give a bit of a thread to my talk. Before I launch in, just a bit of a reminder of the basics. So to be eligible for Section 95 asylum support, you need to be an asylum seeker and you need to be destitute. To be eligible for Section 4 support, you've got to be a rejected asylum seeker, you've got to be destitute, and you've got to satisfy one of the criterion in Regulation 3.2 of the 2005 regs, which basically means you've either got to face a practical or legal impediment to return to your country of origin, or there's going to be a human rights breach. And accommodation under Section 95 has to be adequate. That's the statutory requirement, and any financial support must meet essential living needs. So I know for a lot of you that is going to be teaching you to suck eggs, but I'm really just reminding you, those of you who do not practice in this area habitually, of the basics, to help you follow what I have to say, because quite a few of the cases I'm talking about today are not the principles in them are not limited to asylum support. They've got more general applications. So if you know the basics, it might help you pick those points out. And the first case I wanted to talk to you about is a good illustration of that, because it's about when support is needed to avoid a breach of the ECHR. So early in spring of last year, the first tier tribunal asylum support had decided that all failed asylum seekers were entitled to Section 4.2 support to avoid a breach of the ECHR, owing to the risk both to themselves and to the public at large of contracting COVID-19, specifically during the peak of lockdown restrictions, which made it difficult for people to leave the country. So that was a decision of first tier tribunal. And in the first case I wanted to refer you to, the High Court, Mr. Justice Chamberlain, found that that decision was wrong. He was prepared to accept a positive obligation under the ECHR to avoid, to protect public principle, but to protect public health. But how the Home Secretary should go about doing that was a matter of high principle, so basically not a matter for the courts. So risk to the public is not something that's going to result in a blanket policy that accommodation is to be provided. However, the sort of practice point to take away from this is that the risk to the individual client is still going to be relevant. He was prepared to accept that risk of breach of the ECHR in an individual case is always going to require a multifactorial assessment, and that risk of contracting COVID and risk from COVID could meet the relevant threshold, but you're going to need to make representation supported by evidence on the facts of the given case. The interesting point which I'd add to that from this case, which I don't really have time to do justice to now, was a concession by the Secretary of State in that case for those persons who don't qualify for support from the Home Office ordinarily, who had been accommodated during the pandemic when there was a temporary pause on evictions. They've been accommodated under the royal prerogative. And I think that's an interesting point, because this is effectively a power that none of us knew existed in this context, which is of completely uncertain scope. We don't know when this power will be available, when it should be exercised. So those are questions left open by this case. When does this new power under the royal prerogative arise? Second tranche of cases relate to process, i.e. how do you go about getting support, and specifically, what do you do if there is delay in the processing of your application? Two cases applying the well-established public law principle that statutory functions needed to be discharged within a reasonable timescale. So first case, AO, there was a delay of nearly 8 months in processing a Section 4 application. That delay was unlawful and meant that the applicant in that case had been detained unlawfully during the time when he was not released from detention because of a lack of accommodation. Second case, similar facts, Babbage, delay of 10 months unlawful. So no new principles there, but the facts of those cases I think are worth flagging up, because delay is such a widespread problem in community care. The first case, AO, what made the delay unlawful was the quality of the delay, not just the quantity of it. It was the fact that throughout this 8 months there was error and inaction on the part of the Home Office. The second case, Babbage, I think is useful because it gives you an idea of what in the current circumstances the court will regard as acceptable as well as unacceptable. So specifically, of those 10 months, the first 2 months were lawful. So the High Court was prepared to give 2 months latitude, saying a month to process the application, a month to find accommodation. And that was without any evidence from the Home Office of why that was necessary. The High Court, Mr. Justice Sewell, was prepared to presume that because the pandemic was going on, these things will take a bit longer than normal. Third and final theme I wanted to touch on is service provision. So what do you actually get once you've qualified for support? And I've divided these cases into 2 parts. So firstly, I'll deal with financial support to meet essential living needs. And this specifically is financial support under Section 95. So 2 useful cases to flag here. The first is JM, the second is AXG, and they both involve similar subject matter. So as I said at the beginning, increased use of hotels last year to accommodate asylum seekers because there was a blockage in the system with the pause on evictions. Hotels, generally speaking, are full board, And so those who were placed in hotels were not getting the cash allowance which asylum seekers normally would. The working assumption of the Home Office was that people's needs were being met in hotels because they were getting meals there. And so they weren't providing any cash over and above that for things that the Home Office would normally regard as essential living needs to avoid destitution. So specifically, no money for clothing, no money for travel, no money for non-prescription medication. So that's things like, paracetamol, ibuprofen, Calpol for kids, that kind of thing. So there was lots of people in hotels. There's about 90 hotels in use for this purpose, but nobody was getting any money for this. That changed in October 2020 as a result of a series of challenges, policy change at the Home Office, where it was decided that payments of £8 a week would be made on an ongoing basis to those in hotels, which was to cover things like clothing, and that would be backdated to March 2020. And also payments would be made to cover travel going back to July 2020. So partial backdating challenged in these two cases, JM and AXG. So in JM, the essential living needs in question were travel and communication. And the High Court said that the fact that there was no provision within either the backdated payments or the payments coming forward for communication was unlawful. But in respect to travel, the fact that there had been partial backdating was lawful, because the partial backdating going back to July married up with the COVID restrictions. So the reasoning of the High Court was that between March 2020 and July 2020, people shouldn't have been travelling anyway. So that part of the Home Office policy was lawful. And then AXG really mopped up the additional points that weren't decided in JM. AXG involved non-prescription medication. So as I say, things like paracetamol and ibuprofen. Mrs. Justice Stein in that case held that the failure to make backdating payments for non-prescription medication was unlawful. But there was also a wider challenge in that case to the idea of having a long stop. This has been a long-standing issue, having people in hotel accommodation. It didn't start in March 2020. So the claimant in AXG was challenging the imposition of a long stop going back to March 2020, saying, well, why should it be then? Why shouldn't it be from the point that the person was put in the hotel accommodation? And Mrs. Justice Stein agreed with the reasoning in part. She said that prior to March 2020, it had been the case that the Home Office was failing to meet essential living needs by not paying for clothing, by not paying for medication, etc. However, the later decision, the October 2020 decision to backdate, was a separate decision. It was an exercise of discretion on the part of the Home Office to remedy its earlier failings. And that discretion was not exercised irrationally in deciding not to provide money for the complete amount, because there were other competing factors, like the need to have an administratively workable rule. Final cases on service provision. I've dealt with money. Obviously, the other part of service provision is accommodation. And the two key cases I want to flag. The first one, I'm sure you'll be familiar with, even if you're not on top of the detail. NB was the challenge to the decision to use Napier barracks to accommodate asylum seekers. There was an awful lot going on in this case, an awful lot of legal issues. I'm not doing justice to all of them here. I just want to focus on adequacy, which was the claimant's challenge to the use of the barracks for this purpose, saying that they were not adequate. They didn't meet the statutory requirement of adequacy. High Court's Mr. Justice Linden agreed with that attack, and in doing so, he held that the Reception Conditions Directive continues to apply, notwithstanding Brexit. So that's important, because what it meant was that the statutory requirement of adequacy has to be interpreted in light of the Reception Directive. And specifically, that means that to be adequate, accommodation has to ensure a standard of living adequate for the health of the applicant. And I think that's useful, because I think that's a much easier standard to apply. Adequacy is quite a elusive, amorphous conduct. But when you ask whether or not accommodation is adequate for a standard of living for the health of a person, really you're just asking, is it making their health better or worse? And if you've got evidence it's making it worse, it's inadequate. Some interesting discussion, which I won't go into now, about the relevance of the contractual standards imposed by the Home Office on the third-party contractors it works with, so Clear Springs, G4S, about how those standards relate to adequacy. Perhaps we can come back to those in the questions if you're interested in those. And then the final case, as I'm coming to time, is case of Hussein from November, which was a case where a vulnerable adult who was living with a friend who acted as his carer was trying to persuade the Secretary of State to provide him with effectively subsistence-only support under Section 4. He was arguing that he could stay with his friend and the Home Office could discharge its accommodation functions by allowing him to stay with his friend and just provide money to top up the rest of his support. High Court said that the Secretary of State's refusal to do so was not unlawful. In principle, the Secretary of State can make arrangements to place somebody in private accommodation. It doesn't always have to be accommodation through Clear Springs or through Mears, etc. It can be a private arrangement, but on the facts of this case, the refusal to exercise the discretion to do that was not unlawful, because the claimant had said that it would generate significant cost savings to the public purse to do so, but there wasn't really much evidence of that. So a lot's happened. Happy to expand on any of those in the questions, but that takes me to time and I will stop there.
Great, thank you so much, Connor. Our next speaker is Miranda Butler. Miranda has a broad public law practice with expertise in unlawful detention, healthcare, trafficking, and of course community care. She is also a member of the EHRC's panel of preferred counsel and was a finalist in 2020 for a LALI, a Legal Aid Lawyer of the Year award. And she is going to talk to us today about trafficking.
Thank you so much, everybody. Can everybody hear me and see my slides?
We can, Miranda. I think we may be seeing the presenter's view of the slides.
Is that a bit better?
That's better, yeah. Thank you.
Excellent, thank you. My two screens decided to go backwards. So I'm going to be covering a small number of cases than I very admirably managed to get through in their allotted time. And I should start by acknowledging that whilst this is technically a review of 2021, at least two of my cases go back into 2020, but are still interesting to note or of ongoing relevance. The cases I'm going to cover fall into three broad areas, all concerning the rights and interests of victims of trafficking, the support that they get, both prior to being aware of conclusive grounds decision and after that stage. Firstly, I'm going to talk about EOG and KTT, which concerns leave to remain in post-conclusive grounds decision. I'm going to shadow some of the points that it's made about the financial support given to victims of trafficking in hotel accommodation. And I'm finally going to touch on a case last year about the right to work for victims of trafficking. Those of you who can back to the end of 2020 may well remember Justice Marstons' decision in EOG in the High Court. EOG is a now recognised victim of trafficking who was referred to the NRM at a time when she had leave to remain in the UK, but that leave expired whilst it was under consideration, in part as a result of the fact that they were found doesn't activate the existence of leave. And she challenged the lack of any provision in the Secretary of State's policy for granting leave to remain to potential victims of trafficking. So Mr. Justice Marston held that there was an unlawful opinion in the Secretary of State's policy which failed to implement litigation under Article 10.2 of the European Convention on Action Against Trafficking, which prohibits the removal of individuals who are awaiting a final decision on the status as a victim of trafficking. That's part of the broad obligations to protect those potential victims and support their recovery. And he concluded that leaving such individuals as focus areas or simply as unlawfully present doesn't comply with those obligations. To accept an argument based on the, perhaps one might be slightly clearer language of Article 13 of the Act, which provides that they should authorise victims' residence in the UK during the recovery and reflection period, and instead simply relied on Article 10. His conclusion, which I quoted there, is quite powerful, where in his words, they are left as overstayers, branded as criminals, deprived of access to basic services, unemployed, dehumanised and penalised. And those factual findings lead very directly to his conclusion that the policy lacuna that I discussed earlier, not allowing for any consideration of leave to remain whilst victims are within the NRM, was incompatible with their right to recovery. If we could go on to the next slide, please, Amy. It's also worth noting briefly that Mr. Justice Mostyn is extremely critical of the very lengthy delays within the NRM. He noted that in 2019, the Secretary of State had assured the court that delays were improving and appropriate resourcing was going into it. But unfortunately, they have, in his words, gone from bad to worse. And in my experience, that has only continued since his decision at the end of 2020. And if we can move on to the next slide, the other case that should be considered alongside the EOG, although they do concern slightly different targets, is the case KTT. This concerns the situation of recognised victims of trafficking who received a conclusive grounds decision. The quite straightforward argument that was put forward by the successful claimant was simply that an asylum-seeking recognised victim of trafficking requires stay in the UK in order to pursue their asylum claim as a matter of their personal circumstances, and that therefore they fall squarely within the language of Article 14 of the European Convention on Action Against Trafficking, which concerns the grant of residence permits to recognised victims of trafficking. The Secretary of State's policy at that time, and in fact still is, that discretionary leave would not normally be considered before the asylum claim is determined. So even recognised victims were being left in that limbo situation that Mostyn described so powerfully. Therefore, Lindsay found that the failure to grant leave to asylum seeking victims of trafficking was unlawful. There was also a point that has been raised in both cases by Secretary of State, who argued that the European Convention is not justiciable, that as an unincorporated international treaty, it should not be considered or applied by the domestic court. And that is a matter that is still outstanding. If we could go on to the next slide, please, Amy. It's still outstanding because the Secretary of State has appealed both decisions. The cases have been linked by the Court of Appeal and are currently listed for a 4-day hearing from the 8th of February. The Air Centre is intervening in the KCFOG and has been given permission to do so in KTT. It will probably be a significant judgment whichever way it goes. When the KCFOG was first due to be heard in the summer, but was adjourned as a result of the Secretary of State raising the justiciability point at the 11th hour. It was due to be heard by the President and Deputy President of the Court of Appeal, and also by Lord Justice Underhill, who I'm sure attendees will be aware is a leading expert in this area. So this is very much a watch this space update. If we can move on to the next slide, we're now changing topic here, and we are picking up on what Connor said about the pause and dispersal from initial asylum accommodation. As Connor noted, no financial provision was given to individuals in asylum accommodation, and that included in July 2020, a unilateral and unannounced cessation of financial support to victims of trafficking in initial accommodation, including a complete cessation of the support that they received in order to meet their trafficking needs. The support was subsequently reinstated, but it was cut from £65, which victims of trafficking were initially receiving, to £35. Applying the clear language of Secretary of State's contemporary policy, the Deputy High Court judge found that at this time, the Secretary of State was obliged to provide £65 to victims of trafficking in a initial asylum accommodation, even where they took full board. And whilst that was somewhat inconsistent with the arrangements made for those in self-catered accommodation who also received £65, the language of the policy was clear, and this was simply a mistake on the part of the Secretary of State, insofar as she argued that she intended to give victims a different sum where they were in catered accommodation. This is a rather retrospective judgment, only concerns victims of trafficking who were in initial asylum accommodation at the time of this cessation, so broadly in 2020. However, the full extent of judgment is to be explored tomorrow in a consequential hearing, which I understand will be going ahead probably in front of Mr. Justice Linden. Finally, I'm going to go back to 2020 again and just remind us, amongst a number of decisions that there have been about the right to work recently, including C1 and Cardona, that there was a decision regarding the right to work for asylum-seeking victims of trafficking. And the principle in this case can be quite simply articulated, namely that the Secretary of State accepted that she had a residual discretion to grant permission to work outside the shortage occupation list and outside the terms of the immigration rules. And that residual discretion has to be exercised with regard to the objectives and purposes of the European Convention, including the purpose of recovery and support for potential victims. The policy failed to reflect that obligation and was therefore unlawful. The policy has now been amended, albeit in quite light touch terms, and these are certainly applications that practitioners should be making, given the essential role that a right to work plays in victims' recovery. Thank you very much. I'll be very happy to answer any questions.
Great, thank you so much, Miranda. I think you win the prize for most time-efficient presentation. Ollie is a public law barrister with particular expertise in education law. He is a former lecturer and he is on the steering committee of the School Inclusion Project and a committee member of the Education Law Association. And he is here to give us his expertise on the last year in education law. Thank you, Ollie.
Thank you very much, Tessa. I'm just going to try and share my screen. In short, I'm going to be covering 4 recent upper tribunal decisions in the context of special educational needs. I'm not attempting to cover all of education law in the last year. So I'm going to be entering through 4 upper tribunal decisions, which I think are of interest. I'm not attempting to summarise them in detail. I'm trying to highlight the key points for practitioners in this area. But please do read them in detail. They're important decisions. So I'm going broadly in chronological order, and I'll be spending the most time on the first 2 decisions. So VS and RS against Hampshire County Council. And this concerns a very important issue of social care and healthcare recommendations. So all education law practitioners will be familiar with the extended powers of the first tier tribunal and previously the national trial, which brought into scope health and social care elements of an EHCP, an education, health and care plan. While the tribunal cannot make binding decisions, it can make recommendations. And this is one of the few upper tribunal cases to consider the status of those recommendations. And unfortunately for claimants, it's not a good decision. In decisions regarding sections B, F and I, so the education provisions of an EHCP, so B and F primarily, provision must be specific and quantified, and the test is must. However, in the regulations regarding social care recommendations and healthcare recommendations, it's should, which the upper tribunal in VS held to be a less rigid standard. Ultimately, it gives local authorities a bit more leeway regarding the content of the health and social care parts of an EHCP when they are being examined by the first tier tribunal. However, the first tier tribunal, as the upper tribunal in this case was keen to point out, is not the only way that you can challenge problems with the health and social care elements of an EHCP. It noted at paragraph 54 that it's an attempt to further mitigate the differing forums for dispute resolution, but it is not a single route of dispute resolution. So there is the potential for judicial review, etc. The upper tribunal also gave a steer that recommendations about future health and social care reviews would be a helpful way of meeting the lower threshold of what constitutes a suitably specific and flexible provision for the purpose of health and social care. So the next case is NN against Cheshire, and this concerns EOTAS, or education otherwise than at school. And EOTAS has come to the fore for many education practitioners as a result of the pandemic and children being out of school for extended periods of time. In layman's terms, EOTAS is quite often considered to be a transition package to get a child back into school if they, for some reason, cannot attend the school or any school. Now, the test for EOTAS is set out in section 61 of the Children and Families Act, and it's always been a very difficult area for education law practitioners to grapple with. And the upper tribunal in NN has provided clear guidance consolidating different strands of case law in paragraph 47 of its decision, which all practitioners considering an EOTAS case should now look to. Now, I've set out what the EOTAS guidance from the upper tribunal in my slides. I'm going to briefly canter through them, but you'll be sent the slides and you can also read the decision. So the first point is fairly obvious. You must consider section 61, that's the test, and it's a two-part test. The next B, the tribunal must consider section 61 and must separately ask whether it is satisfied that it would be, oh, that's the same thing, my bad. But B is actually meant to be the list of considerations that they're meant to take into account, which is a non-exhaustive list. So the child's background and medical history, the particular educational needs of the child, etc. These are all well established, but it's useful to have it set down as part of a longer test. C, if the tribunal is satisfied that it would be inappropriate for any such special educational provision to be made in any school, then section I must be left blank. And that had previously been a source of contention that had been settled in a relatively recent upper tribunal decision. However, if it's not satisfied that it would be inappropriate for any such provision, and I think that's the key takeaway from this, it's re-emphasising the line-by-line approach to provision in section F and whether any school could be appropriate to meet need. Conversely, if it is any part of that provision could be made in any school, you should be naming a school in section I of an EHCP. Then there's some consideration about the definition of the term school, which is helpful. I'm not going to go into in any detail. And similarly, section F, I'm not going to go into any detail. You can read it in the judgment. I'm cantering through this. But it's always a helpful reminder what was put at G. What is specified in section I must strictly be limited to the name of the school. So you can't put further descriptions in it. So name or type of school. So you can't put additional descriptions in section I. That's unlawful. And that was the rationale for leaving section I blank for EOTAS. So next case is case of JL, which concerns the meaning of the term academic year. Now, this case might be considered a little bit niche because it concerns section 46 of the Children and Families Act, which confers a discretion, it's a power to extend an education healthcare plan beyond the age of 25. But so if you're doing an FTT appeals, many of us might have assumed that it wasn't that relevant because there's no power for the tribunal to order extension of an EHCP in accordance with section 46. However, what's really interesting about this guidance is it's just, so you need to distinguish between regulation 46 here and section 46. That's just a little bit of a health warning when reading this judgment. Regulation 46 is the SEND regulation. Section 46 is the Children and Families Act. So when you're looking at the definition of academic year in Regulation 46, the tribunal is clear that it's a context-sensitive question, and what constitutes an academic year depends on the type of education that the child is receiving. So it could, in theory, extend to one day before the child's 26th birthday. And as I said, there's not a duty to extend. The tribunal cannot order an extension, but in this decision, it was held to be a materially relevant factor that as to the local authority the local authority's discretion is relevant to the tribunal's analysis of what provision should be put in section F. And that is the key thing to take away from this decision. The next case is a wide-ranging one, and I want to unpack it a little, but I'm not going to be able to do it justice in a limited time that I have available. So the case is called MS and LS against Wakefield Council, and technically it got handed down earlier this year rather than 2021. But as it was heard in 2021, I think it can fall into our review of 2021. So there are a few health warnings from the upper tribunal here for practitioners in approaching first-tier tribunal appeals. The one of more general application, which isn't confined to the facts or the particular substantive legal issues here, is coming to an agreed list of disputes between the parties and the effect that will have on the operation of the first-tier tribunal's decision-making. So this case concerned section I and the appropriateness of the placement in section I. And the parties had agreed, so it was they're looking at B, F and I, like the usual appeals in this area. And the parties had agreed that the list of disputed sections in section F, so section F or non-education practitioners is provision. The list of disputed sections in the list of disputed issues in section F was in relation to the provision currently being made in the school. Now, because they were the disputed issues before the tribunal, that limited the scope of the tribunal's inquiry as to whether the school would be appropriate at meeting future any other potential provision under section F. Now, the upper tribunal is clear that it may well have been different had the first-tier tribunal been asked to address whether a certain school was capable of delivering any section F provision that it was not, or might not have been currently providing. However, as the tribunal hadn't been directed to consider that, it had narrowed the legal question, and as such, there was no material error of law. The other 2 points that I picked out of this very interesting and detailed judgment, which is worth reading in full, is the importance of speech and language therapists' evidence. And for education practitioners, a speech and language therapist is a key part of the communication sections of an EHCP. Now, it's probably a well-established point, but nonetheless an interesting one that was given some discussion in this upper tribunal decision, which was that SALT evidence goes beyond the appropriateness of direct provision of speech and language therapy. And this case concerned an autistic child, but their evidence was relevant to the wider communication needs that that child might experience, or any child might experience. Now, the final point is we're seeing the decision of Lord Reed in the UK Supreme Court in the case of SC trickle down into the lower courts and tribunals, and in a perhaps unfortunate way for claimant practitioners. The key ground of challenge here was that appellants were trying to argue that appropriate required a purposive construction compliant with the European Convention on Human Rights. That argument, unfortunately, did not fly because the upper tribunal found that the term appropriate in section 40, subsection 2, which is referring to appropriate placement, was not in doubt, and therefore you don't apply there was no room for a section 3 Human Rights Act compliant construction here. The fallback argument of the appellants in this case appeared to be that actually there was a standalone UNCRPD breach, and that actually in effect there was segregation in breach of the UNCRPD. And an application of the case of SC found that CRPD, sorry, not UNCRC, the UNCR, that it would apply with equal force to UNCRC. The UNCRPD was not something that should be assessed independently when looking at the question of appropriateness or probably any part of an EHCP. So that's my brief canter through. I'm sorry if I've gone over time, and thank you very much for listening.
Great, thank you so much, Ollie. But we do have time for some questions, so thanks to everyone who's been putting them in the Q&A box. I'm going to start with a question for Connor, which is from Bianca, and the question is whether once the pandemic's over, assuming that does happen, whether we'll see more tourism coming back into the country, and as such, whether hotels will still be used to house asylum seekers, i.e. has that now become the norm, or will we be reverting to the previous state of affairs? And if so, what do we think the social implications of that might be? That's perhaps a sort of practical and social question rather than a strictly legal one, but I think it's a very interesting one all the same. So Connor, do you have any thoughts on that?
Legally, there's no statutory bar on it becoming the norm. There is nothing in the legislative framework which says that you can't put people in hotels in discharge of your statutory frameworks, subject to the caveat that the accommodation always has to be adequate, which are discussed in the presentation. Politically, though, I think it will probably return to the pre-pandemic situation where hotels aren't used for the simple reason that they're pretty expensive. And we have a Home Secretary who is not noted for her humanity and is a enthusiastic proponent of the idea of benefits tourism, i.e. the idea that people flee war and conflict specifically because they want to come to England to stay in a Premier Inn at Heathrow Airport. Now, I'm not entirely sure that's a logic I agree with, but as I'm not the one making decisions and Priti Patel is, I think that kind of thinking is likely to mean that we will head back to the pre-pandemic situation where hotels aren't used as much as they were. As to social impact while they are used, well, we saw this before the pandemic with homelessness, mainstream homelessness accommodation, where families are routinely put in hotels, B&Bs, and the social impact is pretty devastating, particularly for families with kids. You cannot expect children to thrive when they have to do their homework on a bed in a hotel and they don't have a desk, where they're eating terrible hotel food or takeaway and don't have access to proper cooking facilities, and when, because they're in accommodation where they're not getting full cash payments, they don't have any money for toys, for education, anything like that. So yeah, social impact is devastating, but my hope is that use of hotels will diminish in due course.
Thanks very much, Connor. Ollie, this is a question for you, and it is, if a child has a medical condition that prevents them from attending school, but the local authority requires, quote, evidence of that disability before providing education, could that be capable of amounting to disability discrimination?
I'd have more fundamental concerns than a disability discrimination claim. It seems like a Section 19 Education Act issue. Yeah, I mean, it sounds unlawful for many reasons. Without knowing more facts, it's quite hard to say whether that could constitute disability discrimination. But the duty to provide education is a more general one. It seems like they would have issues under Section 19 of the Education Act, 1996, potentially disability discrimination too.
Great, thank you very much. Connor, back to you. This is a question which relates to two recent cases. Did Queen on the application of AO or Queen on the application of Babbage, both cases against the Secretary of State for the Home Department from 2021 in the High Court, did either of those cases set a standard for the length of time for which detention was lawful in order to source asylum accommodation, or will that be a case of application on a case-by-case basis?
It's a case-by-case question. I mean, I should say in both of those cases that there were a lot of other factors at play which made the detention unlawful. It wasn't just the failure to provide accommodation. That's just the one I've picked out for today's purposes. There were other errors going on in the background, but the failure to provide accommodation meant that the detention was unlawful during that period, and the benchmark for whether the failure to provide accommodation is unlawful is whether the delay in providing it is unreasonable, and that is an inherently case-by-case fact-specific question. All that AO and Babbage do is give you a full few indicators of when delay may or may not be unreasonable. So in AO, as I said, there was inaction and error on the part of the Home Office, which meant that their delay was more culpable, and that meant that it was unreasonable. In Babbage, the fact that we had a pandemic which made the discharge of public functions more difficult meant that was that initial period of a couple of months at the beginning where it was reasonable, but then after that it became unreasonable. So it's fact specific, but there's a few hallmarks from those questions you might take to your own cases.
Thanks very much. We have a few more minutes. If anyone else has any questions, please do put them in the Q&A box, and we will endeavour to answer them. Right, there's another question for you, Ollie, from Matthew. You mentioned a CRPD argument being raised, albeit unsuccessfully. How effective is arguing the CRPD in the courts? And given that it was argued in the alternative, is that indicative of it being used as a, quote, Hail Mary? So Ollie, do you have any thoughts on that?
Plenty, actually, but to be clear, it was argued as an independent ground of challenge, effectively, within an existing ground of challenge. So there was a construction based on the ECHR, section 3 HRA, and then there was a sort of separate argument that saying you should look to the UNCRC when measuring this standard for what is appropriate. That challenge failed. I think the UNCRC, and SC confirms this, is still relevant, applying what's called the Newlinger principle of harmonious interpretation. So we've seen it in cases such as Burnett and Matheson, that when applying Article 8, you apply it or any other convention rights, you have to apply it harmoniously with international treaties like the UNCRC and UNCRPD. So you can look to those substantive rights to inform the construction of your convention rights, but without the hook of convention rights, which the upper tribunal considered to be shut down in this case because there wasn't any ambiguity about the term in this the term appropriate in this context, there wasn't that opportunity for that purposive construction taking into account the international treaties. But those international treaties are alive and well if you can get them in through the Human Rights Act.
Great, thank you very much. A couple of minutes left. If there are any more questions, please do pop them in the Q&A box. A question from Gloria, and I think this is probably a question for Connor and Maria, maybe, but if anyone else wants to jump in, please do. And the question from Gloria is, how has the position improved for unaccompanied minors placed in detention-like facilities facing an age assessment? And how can an advocate support a child who's in that situation, who's experiencing poor mental health, and the Home Office are delaying or being unresponsive? So, Maria, do you have any thoughts on that, or Connor?
sorry, I'm not sure I understand. Delaying in conducting the age assessment or delaying in responding to a request to release somebody from detention?
Well, I suppose it would be in responding to a request to release. If you've got a situation where you've got a child who's in a detention-like facility experiencing poor mental health, and you've got a delay from the Home Office, or perhaps it could be a different agency, any sort of practical tips on how that child might be supported?
I think obviously if they've got access to anybody that can make representations on their behalf in relation to vulnerability, even if it's just suspected mental health issues or other vulnerabilities, that would be the starting point. And then if there's a continued silence from the Home Office, then at that point sort of seeking legal advice on next steps to challenge the failure to engage or to consider releasing or undertaking an age assessment.
Thank you. Miranda, I don't know if you can hear us. I suppose the damage to mental health whilst being sort of held in Home Office facilities is something that will also affect trafficking victims potentially. I don't know whether you want to kind of add anything on that, or if you, I know you're probably not able to see the question, but if you have any thoughts on that.
No, well, I think the thing that I can add, and it's probably something that a lot of the other panelists can confirm, is that I've represented few clients whose mental health hasn't been adversely affected by being placed in particularly initial accommodation. But I'd also want to highlight that in the case of victims of trafficking, beyond the incompatibility with that kind of accommodation for victims' recovery, there's also potentially a risk of re-traumatising individuals who previously had no choice about their accommodation, have been held in very poor conditions, and also some traffickers have been known to target individuals in that kind of accommodation.
Thanks, Miranda. That's really helpful. So we're now at 18:29. So unless anyone has any other questions, let me just see. Quite a long question's just come in. I'll just see. This is quite a long, quite fact-specific question. So as we're now at time, I'm going to suggest that the contact details have been put at the end of each slide. So it might be best to make contact afterwards, although I think Connor may be assisting with that question.
Yeah, I mean, briefly, if you get a negative decision because the Home Office is saying you haven't got enough evidence, then just appeal. The Asylum Support Tribunal will take a much more sensible view on what constitutes proper evidence. And if you need assistance with preparing the appeal, then get in touch with the Asylum Support Appeals Project, who are fantastic.
Great. So that was a question about, a negative decision from the Home Office on the grounds of sort of lack of evidence and what to do about that. And kind of saying appeal effectively to the Asylum Support Tribunal, who will take a more relaxed approach to the evidence. Great. Well, thank you, everybody, for coming. Thank you very much to our speakers. The slides will be sent out after the seminar, and the recording will also be available. So it just remains to me to say, again, thank you to everyone for coming, and to the speakers, and to wish you all a very pleasant evening and end of week. Thank you.